You have left files on my table. They're still files. Good morning. Or is it good? Still not connected?
Yeah, just connected.
What are these things? No. I need my space.
Charles Mogere. I'm mentioning criminal case number 33 of 2019. The accused is in court and the advocate is Mr. Kaba. Is Mr. Kaba online? Mr. Kaba? Okay, make your application. Naelewa lugha gani? Swahili.
So
Hold on. Richard na Joseph na Cyrus. Mtangoja kidogo, ninatafuta who is for that accused person. You have an application to make.
Kaba.
Mr. Kaba.
My matter is appeal about what 27
Just hold on, I'm addressing a matter.
Kwa leo kesi ilikuwa inasikizwa.
And we expected the IO.
Tulikuwa tunatarajia ule afisa ambaye anda retire.
So his colleague who conducted the same investigations together in the foreign journal.
Mkuu wa mashtaka anaomba kuahirisha kesi
to decide on who going
The court should review revoke the grants issued by supported by Francis Ongeri Mwenga's affidavit. Now the respondent in her response filed a statement of grounds of opposition arguing that the application is burdening law and abuse of the court process. It is also res judicata that the court has no jurisdiction. The respondents also filed a replying affidavit on 12th of November 2021. The application was dispensed by way of written submissions. The applicant highlighted the following issues for the court's determination. First, whether the grant issued on 20th of June 2016 should be revoked, and secondly, whether the court had jurisdiction to cancel titles. The respondent in their submissions maintained that the application is res judicata. I have considered the pleadings, the submissions of the parties on the evidence on record, and the preliminary issue for determination that should be considered by this court before considering the merits of the application is whether the application is res judicata. The applicant petitioned for grant of letters of administration, and in his affidavit in support of the petition, he averred that the deceased was survived by himself, signed on Mio Omwenga and Justice Ombiri Omwenga. The respondent, together with Milka Wamboka and Anna Kenito, filed summons for revocation of grant dated 20th of June 2012. The summons for revocation of grant was set down for hearing. And at the hearing, the parties entered into a consent that was adopted by the court. The court made the following orders. One, that the grant of letters of administration issued on 21st of December 1999 be revoked. A fresh grant was issued in favor of the applicant and the respondent to jointly administer the estate. The grant issued to the administrators were confirmed on the following terms: that the estate of the deceased was to be agreed to comprise of parcel number 1, Central Kitutu, parcel number 1273, and 1264, and the other parcel number 1264 was to be allocated to the second house of Francis Ongeri Omwenga, Robert Mososi, and Ansi Kwamboka. 1273 was to be divided into two portions, each measuring 0.57. One portion was to be registered in the name of Francis Ongeri to hold in trust for himself and members of the second house. The other portion was to be registered in the names of Sabina Mora to hold in trust for members of the first house. In due course, the applicant filed an application dated 2nd of October 2019 seeking to set aside the consent order. The application was considered by the court, and it was found that the applicant had failed to demonstrate that the consent order was obtained fraudulently by misrepresentation, collusion, or mistake. The respondent has thus raised the issue of res judicata under Section 7 of the Civil Procedure Act, which I have quoted and I will not read. Now, in the case of Independent Boundaries Commission, the court discussed what constitutes res judicata, and there's a paragraph of that. Now, I would actually agree, considering the background of this matter, I would actually agree with the respondents that the issues raised by the applicants are res judicata to the extent that they are similar to those raised in the application dated 2nd of October 2019. The application dated 20th June 2012 that the applicant seeks to strike out was determined by the court through the consent judgment recorded on 31st of August 2016. The application for setting aside the consent judgment was also determined by this court in its ruling dated 27th of January 2020. To consider the application would mean that this court is sitting on its own appeal. Following the foregoing, the application dated 5th of September 2021 is hereby dismissed. There shall be no orders as to cost, as this is a family matter. You have heard it, eh?
Yes.
So I go back to Civil Appeal number 13 of 2021.
Tarajia kama kwamba mahakama ingetoa uamuzi wa haki kwamba yule mama marehemu ambaye aliuawa kwa ajili ya shamba yake angerudishiwa shamba yake ili mwili upate kutolewa mochari upate kushikwa. Lakini kwa vile mahakama bado imesema marehemu hana haki ya kukua katika hilo shamba, sasa itabidi tutaenda tena tuite wazee ambao ni wenye kijiji wakae, alafu waangalie mwelekeo mpya. Lakini ya muhimu ni kwamba hatujui kama mwelekeo utakuwa upi, kwa sababu tayari Land Register mwenyewe ametoa record na kusema kwamba some of the title deeds which were issued, the records does not exist with the lands. Sasa hatujui kama Land Register mwenyewe amekataa, there are no records for the title deeds. Na sasa mahakama inasema it is the right procedure was followed and then the title deeds were issued. So what next? We shall have to look on that. Come after we have gone back home, we sit with the majority of the community, we sit down, we see which is the way forward. Lakini sasa jambo muhimu ni kwamba ule mwili bado utabaki kuwa katika hiyo mochari mpaka siku ile marehemu atapata mahali anaenda kushikwa. Sababu hata watazamaji wote nikiwauliza, hakuna mwenye atakubali mwili pelekwe kwake. Marehemu lazima apate shamba lake aende kushikwa huko.
Tutaenda tena kuendelea mbele kupigania haki ya huyu mama ili apate shamba lake mahali ataenda kusikwa. Saa hii sasa kuhusu na ile ambao tulikuwa matarajio tulikuwa nayo ya kuenda kusika yule mama, sasa tena imekuwa sasa tena imechanganywa. Sasa kile ambao tutafanya ni ile ambao ule mama ataendelea kukaa huko mochari mpaka tena tupate hii uongozi mpya kulingana na kesi ambao tutaenda kuweka tena mpya ili tupate haki yake ili apate mahali pa kusikwa. Kwa sababu hata tukimtoa saa hii mochari ana mahali pa kusikwa, kwa sababu hiyo shamba ndio iliua yeye na hakukuwa na shamba wakati alikuwa anapigania apate hiyo shamba, mwisho akawawa. Kwa hivyo tunaomba kama hii serikali yetu tukufu ifuatilie hiyo maneno kuhusu na maneno mataita otiti ya uongo ambayo imetengenezwa na inaendelea kuua watu hapa Kisii. Unaona watu wengi ambao wanakufa siku hizi hapa Kisii ni maneno ya masamba. Na tukileta hiyo makesi hapa kotini na majaji wanaendelea kukataa ati hakuna usaidi ya kutoza na mtu ambao tayari ameuawa. Sasa usaidi gani inatafutwa na mtu ambao ameuawa na ile kitu ambao kimemuua ni hiyo shamba. Si ufuatiliwe sana alafu tujue ni kiini ni nini. Kwa sababu hao watu ambao wanataka hiyo shamba yake ni watu ambao makateri wale wako na pesa nyingi sana.